Welcome everyone to our session today, uncovering and mitigating complex financial schemes post-Comex. My name is Julia Arbery and I'll be moderating the session today. And I'm really delighted to see that we have quite a number of diverse participants, different areas of expertise that have joined us today, as well as from different jurisdictions. Based on the registration, we have participants joining us from the UK, the US, but also from Germany. So that's fantastic, and I'm very excited to moderate this panel today, where really in relation to uncovering and mitigating complex financial schemes, this is aimed at telling you everything that you need to know, may it be that you're part of a financial institution or that you're advising financial institutions. And I would like to introduce the panelists now. We've got Annabel Kerley with us today. Annabel is a StoneTurn partner based out of our London office. And Annabel is leading our investigations practices in London. She's extremely experienced when it comes to financial institutions, financial services, leading investigations involving fraud, bribery, and corruption. Also excited to have David Stern with us. David is extremely knowledgeable when it comes to unraveling business crime, and also is considered a leading expert on the Cum-Ex trading practices. So thank you, David, so much for joining us and kicking us off in a bit. And then we have Joshua Dennis. Joshua is one of StoneTurn's US partners, and Joshua Dennis is really an excellent expert when it comes to data analytics. Joshua has advised clients and their counsel in relation to economic damages, intellectual property, investigations, and any other matters involving financial service industry. So we can now move on to the agenda. And David will be starting us off just in a few seconds in relation to the first point of the agenda, where he will be explaining in detail the Comex trading scheme, how did it work, who was involved, and what was the impact and why is it so complex. Then we will later on be discussing the consideration that you should be having in relation to internal investigations and compliance considerations. We will be having more of a conversation amongst all of the panelists here, before we then move over to really looking at how can we leverage forensic data analytics, where obviously, as I said in the introduction, Joshua is our lead in that, but it will still be a discussion then also with our other two experts, Annabel and David, to see how it all comes together. And with that, I would like to hand over to David to start us on our first agenda point.
Julia, many thanks for that introduction. And the first sort of starting point is just to have a little bit of an understanding about the Comex trading scheme, its background, and to put it into context. So let's turn to the next slide, which just very briefly, in terms of the information on here, but I can expand on that a little bit. Comex is a dividend arbitrage trading practice, which effectively focused on creating multiple economic owners of shares at effectively the same time, that allowed multiple parties to claim tax rebate claims from various EU state treasuries. And it's been estimated that the withholding tax rebates that have been claimed are worth in excess of 55 billion euros. So it's been described as the largest economic tax evasion or tax heist in history. Of course, it's not as straightforward as that, and it's not as stark or black and white as that, even though various prosecutors in Germany and Denmark currently would have us believe. In terms of the focus of today's interest, we're wanting to look a little bit more closely at what the UK regulators and investigating authorities might be doing. But first of all, let's talk about its inception. Dividend arbitrage trading has been going on for some time, and much of it is nothing to do with Comex trading. It's about seeking to take advantage of a favourable tax status of one party over the tax status of another, whether that be the nature of the organisation and what it might be able to claim, or whether because it's based in a foreign jurisdiction, it may have a favourable tax status. And so dividend arbitrage trading is effectively, or in simple terms, moving shares from one party to another with the purpose, either the sole purpose or perhaps at least part of the purpose being to improve the tax status of that. It's not necessarily an inherently dodgy practice or something which should be frowned upon. And indeed, as we go on to look at the way in which it was done, it was carried out in very, very standard form trades that were used to create this. But what's happened is over a period of years, in particular in Germany, it became an industrialized practice. There was dividend season, and during dividend season, there was a great desire to try and create multiple economic owners of the same shares that would allow multiple parties to claim the tax rebate in respect of a withholding tax that was only paid once by the company issuing the share dividend, for example, Daimler or BMW or whoever it might be. And so that practice that started off without huge losses to the state treasuries became a very significant business indeed. And we know from publicly available information that between 100 and 200 financial institutions were involved in the practice. We know that there have been in excess of 400 individual suspect letters that have been sent out across the world, but particularly in London, where much of the trading was actually carried out, saying that the bankers involved in it and the traders involved in it and the customer clients, investment clients involved in it are suspected of committing tax fraud. And so that has caused the FCA and HMRC to become engaged in this. And we know, again, from publicly available information, that a number of institutions and individuals are being investigated by the FCA. And HMRC has become involved as well, because the various authorities in Europe have issued MLA requests for mutual legal assistance, which have been executed by HMRC, issuing search warrants in various institutions or against various institutions in London, effectively a document exercise, recovery exercise, to try and assist and facilitate the investigations in Germany and elsewhere. The SFO is aware of the case, but has not instituted any formal proceedings itself. We're also involved in my chambers in extradition matters that are related to CumEx, which despite the efforts of Brexit and otherwise, which might make that a little bit more tricky in the future, are currently being dealt with under the old regime. And so what are the implications in the UK for financial institutions, their investment fund clients, and indeed the interdealer brokers that were the go-between between the various parties in respect to a practice which started in the early 2000s and ran all the way through to 2012 before the system was effectively changed in Germany, although then morphed into other European jurisdictions. And so you've got criminal investigations in Germany. Denmark has instituted those now as well, in Austria and elsewhere. You've got regulatory investigations, both the FCA and elsewhere, and that's led to a number of settlements that have been entered into by financial institutions already, and there'll be more to come. And then you've got civil recovery actions, which have been commenced in various jurisdictions, including as recently as this week, we had the judgment from Mr. Justice Baker in the SCAT litigation in London, saying that he didn't think it was the appropriate forum for SCAT to litigate. And so that's going to have a significant impact on proceedings going forward, in my view, in the UK, although it's subject to appeal. And part of the reason for Mr. Justice Baker's judgment was that trying to enforce foreign tax laws, which might be opaque, might be open to different interpretations, really isn't a matter for an English judge to deal with. Surely that's a matter that should be dealt with in the local jurisdiction where the tax law applies. So there are widespread proceedings going on, including inter-party proceedings, because many of the financial institutions have morphed over time. They might have been bought or sold, and the legacy issues relating to CumEx may not have been fully disclosed in the due diligence process. So that's creating further lawsuits. And of course, we also know that lawyers provided legal advices about the legality of the scheme, and they found themselves in criminal investigations in Germany as well. So there's a lot of implications here for the UK. And probably the best way of having a look at that is to turn to the next slide and to have a look at what I call a simple German CumEx trade illustration. And the T+2 you see at the top there is quite significant, because realistically, the reason for CumEx and the way in which it could operate all comes around the settlement system when you buy and sell shares, because you can buy on day one, but it won't actually settle for several days after, depending on the jurisdiction you're in. And it's that window between the purchase of a share and the settlement that it becomes the way in which you can facilitate the potential for a second or indeed multiple buyers of shares to be able to have the potential to reclaim a withholding tax. So let's look at the first part of the scheme. As I say, you've got A, the lender, B, the short seller, and C, the buyer. But the first part of the transactional framework is that a short seller, it needn't be a short seller, but very often it was a short seller, would enter into a short sale of some shares. In this example, I've given an example of Daimler shares with the buyer C. And I've given a notional date here of the 15th of May, just so that how we can see that the dates become quite important. And this is the day before the dividend record date, the DRD. The dividend record date's the date upon which Daimler, as we'll see, will actually pay out the dividend to whoever's the owner of the share or the registered title holder of the share on that particular day. So the buyer on this date, buyer C, enters into a purchase agreement for a share from a short seller. Now, what is a short seller? It's someone who does not have possession of that share at that moment in time. But the buyer may not know about that. All he cares about is that he's got a contract agreement for a purchase of a share. And because it's the day before the dividend date, he's purchased and paid for a cum dividend share value price. And that is the gross value of the share on that particular date. So he's expecting to get the dividend. Let's see what happens next. We've got B, the short seller, paying in a dividend compensation payment of 75%. And that's because the average tax on a German share at the relevant time was 25%. So you can see there at the very bottom of the slide, you've got the 25% withholding tax, WHT, being paid directly from the company, Daimler in this case, to the German tax authority. So it receives that withholding tax. Now, of course, that's a prepayment, if you like, of tax, because a withholding tax is simply that. It's something which is withheld by one party to pay to a tax authority that may or may not, depending on the tax affairs of any individual, be subject to being reclaimed at a later date. And so the short seller pays into his custodian bank the equivalent of the net dividend of 75%. So let's then notice as well that on the 16th of May at the bottom, you've got Daimler issuing that payment based on the shareholders recognized on that date. Now, of course, that in fact is lender A, shareholder A, who's probably a financial or pension fund or some long-term holder of Daimler shares. And it's been on the record for some time, and it is recognized through Clearstream, which is the Central Securities Depository, on that particular date, the 16th of May, as the beneficiary of that dividend. So Clearstream pays out to the original shareholder A, 75% of that gross dividend. But that's not the end of the story. If we look at the the next item that will be coming up, you'll see that the short seller, of course, has to pay the equivalent of that gross dividend, sorry, of the net dividend to B. So it pays into Clearstream, and Clearstream's got no way of knowing whether that's a manufactured compensation payment or the actual dividend. So it receives that in, and of course, it's got to pay that out to C. So let's see how that works. And so Clearstream makes the payment to the buyer C's custodian bank. And now, of course, you've got a scenario where Clearstream has effectively paid out, or looks like it's paid out, 2 sets of dividend in respect of that single Daimler share. And so the next stage of this, of course, is that the lender and the buyer need to actually receive the monies. So on the left-hand side, you see that the lender's custodian bank pays it the net dividend, but it also sends out a withholding tax coupon for 25%. In other words, the tax that was withheld and paid to the German Treasury. That allows lender A, shareholder A, to look at its tax affairs and decide and determine whether it's entitled to reclaim or offset that withholding tax. And the German institution has favorable tax treatment in Germany at the relevant time. And so it would simply offset that tax that had been withheld, and nothing wrong with that. But then we have a look and see what happens over on the other side of the coin. Buyer C, it also receives that dividend compensation payment of 75%, and the buyer's custodian bank, which is likely to be a different custodian bank, sees that it's paying out. Not only does it need to get the share to buyer C eventually, but it also needs to pay the dividend compensation payment of 75%, and it also issued a separate WHT coupon. Now that coupon again is sent to buyer C, and buyer C then has to look at its own internal tax affairs to determine whether it's legitimately entitled to make a reclaim of that tax. And for example, if buyer C is a 401k based in the US, it is entitled on the face of it, if nothing else is wrong, to put in an application for a reclaim on a standard form that was issued by the German tax authorities. And so you would then have a second buyer making that claim. But hang on, we've got to get the share to buyer C. So how does that happen? And let's look now at the next arrow, which is the final one you'll be relieved to know on this slide, which is on the next day, the 17th of May, the short seller has effectively probably had a promise to lend. So in other words, a commitment from shareholder A that it would be able to borrow its ex-dividend shares, because remember the 17th of May is the day after the dividend record date. So it would be able to complete the short sale. It would be able to honor its contractual obligations to buyer C because it's borrowed the shares and can transfer those over to buyer C. So that is, and it may not look very simple, but that is as simple as I've been able to break down the trading pattern to give you that example. But it involved not only a complex arrangement in terms of the trades, but also a very clear understanding of the timings of when these trades needed to take place. So let's go on and have a quick look at the next slide.
David, just 1 second. We do have a question from the audience in relation to the trading. And the question is that Comex was first raised in 2012 or even prior to this. And his question is that if that is the case, won't regulators be starting section 166 actions or worse against the entities or heads of compliance at these banks or interbroker dealers themselves? Or will the criminal proceedings in Germany have to complete prior to the SFO or the FCA, PRA, maybe beginning to act against these persons or entities?
That's a very, very good question, and there's quite a long answer to it. I'll try and deal with it and break it down into parts. The first part is that the FCA was fairly slow to pick up on on this. And by that, I mean not the whole concept of it, because back in 2017, the FCA carried out a broad report and made some findings into these sorts of dividend arbitrage practices, but mainly was looking at the KYC issues rather than whether the whole framework of CumEx trading itself was unlawful. In fact, there was some support for the legality of these sorts of trades to be found in the various tax tribunal decisions that have been issued over various years in Germany for it. So there's a slight reticence to, if I can put it that way, for the UK regulators to become too involved too early. And I have some sympathy with that, because if it turns out that after various appeals, CumEx trading is deemed not to be illegal in the country in which it took place, it would be a bit loath for the UK regulators to have made some determination that supersedes that, because of course the tax laws that are in play here are the tax laws in the jurisdiction where the rebate is being claimed. And that's not the UK, because the UK didn't operate a withholding tax scheme of any sort in relation to share dividends. So the SFO is going to even more so be loath to become involved until the findings in Europe have really crystallized. But that's not to say that they're not interested and that they don't have ongoing investigations. One of the difficulties they had was that in that same piece of litigation that I was referring to earlier, the courts had actually said that the FCA investigations ought to really await the outcome of the civil case, because the civil case would have to make some very complex findings, which it would be better placed to do so than the FCA as a regulator would be. Because of course the rules of evidence would apply, parties would submit various pleadings and so on, and it would be tested out. So the short answer is this has got a long way to go yet, and each of the European countries that are interested, and as I've said, mentioned Germany and Denmark has now instituted criminal proceedings as well, will want to look at this. And you might think that those are the best jurisdictions within which this ought to play out, because one of the great reticences of Andrew Baker's judgment was that he felt quite ill-equipped to consider competing opinions about the state of tax laws, because tax has always been something that's been collected in the jurisdiction within which the tax is due, not in a foreign jurisdiction. And we know, for example, that there was a hearing in New York, which has got, the US has got similar laws preventing foreign tax authorities from instituting proceedings. Although in that case, I think it was at a summary judgment level, the proceedings were allowed to continue on the basis that this isn't a tax raising issue. This is out and out fraud. And so the answer to the question that was posed is, I think we're going to have to wait and see how all the dominoes land before we really know how far the UK regulatory authorities are prepared to go. But what I can tell you is that HMRC is active in supporting the investigations which are going on, as it's obliged to do so under the MLA regime that we are party to. So on that basis, if I can move on to the wider marketplace, we've got a highly complex network of parties. They had to provide liquidity and services essential to its operation. You obviously needed to have a large volume of shares available for this to even work or start in the first place. You need to match up short sellers to buyers. You need to have a complex trading practice in place, because the truth of it is that you don't end up in a CumEx trade by accident. A CumEx trade occurs because the parties, although they may not know the full picture, they probably are likely to know that they are a cog in a wheel. And they may well take the view as the lender of the shares that what happens to borrowed stock has nothing to do with it. And I've got some sympathy with that position. In fact, a lot of sympathy with that position. If you lend something out to someone, you're not responsible for what they do with it. I've got some sympathy for the the buyers as well, because you know, they're responsible for their own tax affairs, and they no doubt would have advice from their accountants saying, well, this is, we you know, acquired this share, we're in this favorable tax regime. I've got some sympathy even for the short seller, who almost certainly is likely to be either a large financial institution or connected to one in some way, who would have no doubt received legal advice telling them that this was perfectly proper at the time, and that it only changed. And indeed, even the German legislators morphed and changed their rules over many, many years, trying to stamp out the practice or make it more difficult. But by so doing, almost implied that if you were doing it in one way, that was fine. But if you were doing it another way, it wasn't fine. So you end up in this scenario where you've got to have various parties coming together, and you've got to have these 5 trading legs, as I've set out there. You've got to have the sale of the shorted stocks, you have the purchase of the stocks, you've got to have some sort of collateralized stock loan agreement to facilitate the short sale. In other words, that the short seller isn't left naked and exposed. Might be a naked short seller, but you don't want him exposed. So he's got to be able to borrow the stock. That requires some liquidity. And you've got to be able to hedge out the risk, because remember, the shares are being purchased over a short period of time, but that involves a certain amount of risk as to what happens if one party defaults or if one party doesn't honor its obligations under the agreement. And so that was dealt with through OTC forward agreements or some sort of derivative hedging arrangement. And then ultimately, you've got to be able to return the borrowed stock, because the financial institution who's lent the stock out doesn't want to be sitting there without its original stock in due course. So let's have a quick look at how these trading legs actually worked in practice. And this involved the use of interdealer brokers, quite often in London. And I've given them names IDB 1, 2, and 3, because they wouldn't necessarily always be the same interdealer broker, even within a single CumEx trading transaction. So 1, you see the short seller. Remember, that was B in the previous slide. He enters into the short sale. He uses the interdealer broker because you know, brokers in London and elsewhere are vital to the operations of the financial markets, because you want to have a position where you don't necessarily know your counterparty for entirely legitimate reasons. But of course, in a CumEx trade, and whether this was anyone's intention or knowledge, it does rather create an interesting barrier between the short seller and the buyer. The buyer may not even know who the short seller is. And so the use of interdealer brokers allowed CumEx trading to be facilitated. And so buyer C enters into its purchase of the shares, again using interdealer broker 1. And at exactly the same time, you entered into a derivative hedging transaction between the short seller and interdealer broker 3 in this case, and similarly, so did the buyer. And at this point, then, you've got to make sure as the short seller that you've got an arrangement in place for the loan of the ex-dividend shares. So that's leg 2, if you like. And leg 3, of course, you've got the withholding tax credit that both the lender and the buyer are able to submit to the German tax authority on their standard forms. You have to facilitate the return of the shares, and so the buyer enters into a contract to do that. Sometimes that was actually part of the derivative hedging transaction. So in other words, that the potential if something went wrong was, well, I'll return the share. So in that scenario, it might be the same share. But of course, it needn't be exactly the same share, because we're dealing with all of this on electronic share registers. And so we're talking about ticks on a screen rather than someone wandering around the market with an old bit of parchment. That's not how it was done. And so you see then that the interdealer broker can return the shares to the short seller, and the short seller then can close out and unwind its position with the lender and return the shares back to where they started. And so when you look at this, the ultimate point, of course, is 6, where the German tax authority may be paying out or allowing an offset of tax to more than one party. And again, I've put this in this slide as a simplified version, because this could be done using a number of different types of techniques. You could end up with more than one washing machine, if that's the right expression, or more than one tumble dryer here. That could create more risk to the German Treasury. You could also have a scenario which was called looping, where the same block of shares that were borrowed from the lender by the short seller are utilized on more than one occasion on the same date, because it was possible, if you meshed all of these contracts together at the right time, that you could do this on more than one occasion on the same date. So if you, for example, borrowed 25 million shares and you did it 4 times, well, the risk to the German Treasury, of course, then is on withholding tax being reclaimed on 100 million in respect of those same shares. So that would then have the effect of expanding the risk to the German Treasury. So the idea here is to sort of show how complex it was and the different legs that were required. What this looks like in terms of the aftermath and in terms of what financial institutions need to do, I think I'm going to turn over to Annabel and ask her to shine the light on at least the first steps and some of the wider issues that financial institutions will want to consider.
Thank you, David, and thank you for that really clear explanation of how this really quite complex trading worked. And as you said at the beginning, the aftermath is still becoming apparent. So what is it that financial institutions should be doing in anticipation? So obviously, I think the very, very first thing is to establish whether and to what extent you may be exposed to this scheme by performing an internal investigation. And that will help you inform any decisions on potential self-reporting required. You're forewarned and forearmed, therefore, when prosecutors, regulators, or civil claims come knocking. And you can also, as an organisation, take the resulting opportunity to remediate any problems you find with your compliance programme along the way. So in terms, you need to think very carefully about how to structure the investigation. Firstly, you should be examining what role or roles your firm may have taken. Were you providing the platforms for the equity trading, the liquidity of the hedging? Were you marketing and selling the illicit dividend arbitrage as an investment product? You also need to consider, as always, jurisdiction. This, as David has said, is kind of multi-jurisdictional across Europe. And where is the data that you might be needing to look at as part of your internal investigation sitting? And what associated GDPR considerations are there? And indeed, has that changed over time? As David said, the schemes morphed when German law changed and also moved around to Denmark and other jurisdictions. Another thing to consider is the relevant period and scope of your investigation. The scheme is really quite old now. I mean, if it began sort of 2000, early 2000s, to fully understand, you do need to go back that far, but is that possible? Do you even have the records? And how do your data retention procedures and policies work there? And litigation holds needed. And as Josh will come on to later, is IT on your list of stakeholders in terms of just accessing the data you might need to be looking at? Fundamental to all investigations, this one in particular, would be mapping your potential sources of evidence. And one way to structure this, and I'll come on to this in the next slide, is to look at the product life cycle. Also, what resources and expertise are needed to conduct that investigation? Do you have those in-house, or do you need to go outside of your organisation for help? Do you have data analytics specialists? And might you need trading experts? As we've all seen, it's very, very complex trading schemes that were going on. Independence is also important in this investigation. So any investigation obviously needs to stand up to regulatory scrutiny, and independence will be a key part of that. And of course, legal professional privilege. You would very much want to make use of external counsel in order to maximise the potential available protections that affords you. So I mentioned that one way to structure the data mapping is the potential evidence mapping rather, is to look at the product life cycle. So if we could just move on to the next slide, thank you. I won't talk about all of these, but I'll pick out a couple that I think are really key. I think around new product development and the associated review and approvals with that, the sources of evidence that you might be wanting to look at might relate to the engagement of external counsel to provide legal advice. So emails, engagement letters, invoices, and payment approvals. And when looking at who knew what and when during your internal investigation, other sources of evidence might be product descriptions, minutes of meetings, and sign-offs. So that will help you to ascertain whether the trading was sanctioned at what level the trading was sort of sanctioned and understood in your organisation. Was it at a very senior level, or was it lower down the chain, and was what was really going on kept from those at a senior level? One other point I'll pick out on here is around the new client onboarding. David's talked about this a little bit already, but you might have potentially relevant information in your KYC files. Who were your customers? Who really were your customers? What were the expectations set of their likely activity? And did you as an organisation understand the underlying commercial reasons for their activity? And then down the line, did they behave as expected, and was that reviewed? So I think if we move on to the next slide, please, Tessa. Once completed, this investigation is very likely to have identified room for improvement in your systems and controls. So how can your organisation think about learning from what you may have found and taking in turn the areas I've just discussed? And I will bring in and ask David and Josh to talk as well. What are the compliance things you need to do around new product approval and managing conflicts of interest thereon? I know, David, you've got some insight to shed here a bit around how the legal advice you mentioned at the beginning was obtained and used in this context.
Yes, thank you, Annabel. One of the interesting points about any new investment scheme or trading scheme is that it's likely that external legal advice will have been sought by the financial institution engaging in this to effectively get independent sign-off. And so there's a number of questions that sort of relate to that, because are you looking at just the individual leg that you are involved with and seeking sign-off on your one leg, which might not reveal the true overall arrangement that is actually going on? Who's actually paying for that legal advice? So, for example, in a financial institution, it might be the front office that is actually paying for the advice and therefore controlling the information that's been given to the lawyers. So you want to look quite carefully at what the legal advice was sought for and what it was given, and whether there were any caveats within that, and whether the legal advisors were actually privileged to understanding the full picture. Because as we saw on the previous slides, that you can only really truly understand a CumEx trade when you actually see all the legs that are involved in it. And so I think that's a historical lesson. But going forward, I think a financial institution would be well placed to think about maybe engaging specialist counsel and potentially specialist trading experts, banking experts, to give it that greater degree of scrutiny in terms of implementing a new product, which is clearly designed to take advantage of a tax loophole. And sometimes it's a very fine line between tax avoidance and tax evasion, as we know.
Thank you, David. Yeah, I think it's a really key point. So, what around the conflict of interest point, was there a vested interest in the person seeking the advice and the outcome of that advice? I think so. Moving on to the next point around new product approval, and of course, by the time these laws I'm going to talk about came into force, it's going to be an existing product rather than a new product. But looking forward for additional new products and periodic review of existing products, do you have the failure to prevent tax evasion key principles baked in to when you're assessing your new products. So as we looked at in the original example that David went through, when C goes to claim his withholdings tax, a tax crime or even a fraud may have been committed. And so there is a risk that your organisation, if they've been involved in affecting this, has corporate liability. Have you got anything to add on that point around failure to prevent offences, David?
Well, I just thought I'd add, of course, that the way that the regime is set up, it covers not only domestic tax, but also covers foreign tax evasion as well. So it does actually create the criminal liability in the UK for corporations to be found liable for facilitating, if you like, the evasion of foreign tax, which you know is going to create an interesting legal potential nightmare of interpreting what the foreign tax rules were that applied at the time. But it's certainly there, and the only way around that offence is if you've implemented the reasonable measures and safeguards to prevent that from happening. And so it's critical in terms of any new product approval that you're looking not just at the domestic situation, but also the foreign situation as well, and are regularly updated in respect of both, because the laws can change on an annual basis.
Thank you. And the other point I was going to talk about was the KYC angle, the AML angle. So how can you learn from the experience, and do you really know your customer and your transactions? And is your organisation, through the handling of potential profits through tax crime, handling the proceeds of crime? Do you need to submit SARs? Do you need to improve your process around those? And I know you've, again, David, turning to you, you've got some insight onto who the customers were and where they were, and whether or not they were really understood by the institutions who were onboarding them.
Yeah, I mean, this comes when you look in detail at the defendants in the civil litigation in the US, for example. The list of 401ks. It doesn't take you long to just use your Google functionality to determine that many of these 401ks were single-use vehicles that didn't have any track record, that were based in industrial parks on the New Jersey Turnpike, and one wonders what KYC due diligence, enhanced due diligence, had been carried out to check that these entities were who they said they were, and that complied with your internal systems. And that is something which the FCA is likely to be more interested in, because it's a lot cheaper and a lot easier, and that's not said pejoratively. Any FCA investigation into CumEx is going to be an expensive affair for the national regulator, and KYC is a more easy route to potentially find regulatory breaches than dealing with the questions relating to CumEx itself.
Thank you. So, I think we can move on now. The last point here is around detecting the next LIBOR or CumEx, and hear from Josh on how we can leverage data analytics in that respect.
Thank you, Annabel, and thank you, David. This is obviously a very helpful and educational process for me to hear in real detail about how CumEx trading works, and really think about, Annabel, as you described, kind of the compliance and investigatory concepts that surround that. What I'd like to do for a minute, and thank you, Tess, is talk a little bit about data analytics, and specifically forensic data analytics, and how that could help us as part of this compliance and investigatory process. Just really briefly, when we talk about data analytics here, we're talking about the process of inspecting, cleansing, transforming, and modeling both structured and unstructured data with the goal of discovering useful information, suggesting conclusions, and so really supporting our decision-making along the way. And we talk about in a forensic concept, what we mean there is doing that data analytic steps in a way that can withstand cross-examination and scrutiny, and has an audible, repeatable trail. And that's not just about reaching the conclusion, but about clearly showing along the way the how and the why those conclusions were reached. And thinking about, as Annabel explained, those different sources of information, she talked about some things that we call structured and some things that we call unstructured. For those not familiar, structured data is anything that fits kind of neatly in rows and columns. So if you go to the doctor and they take your height and weight and these days your temperature, and all that fun stuff, they put it in a little table, that's structured data. Unstructured data would be when the doctor asks how you are and writes in very poor handwriting all the things you said, right? Both of those pieces of information are vital to understand who you are and how healthy you are, but how we go about analyzing them would take different types of approaches and tools and technology. So particularly when we have complex scenarios, as David laid out at the beginning here, it's important that we think about the information and utilize all the information, all the facts that we have at our disposal. And I think that's where forensic data analytics can really help, is making sure we're taking all information and bringing it together in a way that is informative. So one reason we do that is to help us see the big picture. Often we look at things in very siloed or narrow focus. When you get a large spreadsheet of trading data, it's really hard to see, looking at any single line item or group of line items, really what's going on. What we want to do is take all that really detailed hundreds, thousands, often million lines of records and being able to present it in a way that allows us to spot those high-level trends and anomalies. What that also allows us to do in a very structured and analytical way is test this different legal assumptions and scenarios. Taking a computer-based approach means that we're creating actual lines of code that allows us to flex and test different assumptions and scenarios in a very clear way. Often, when we work with counsel a lot, if there's two different ways to look at something, they're going to understand the impact of each of those legal assumptions in terms of formulating their final conclusions and opinions. And ultimately, it's about telling a compelling story. What are we seeing holistically, big picture, right, in terms of what was happening? And that really goes into uncovering relationships. Because again, it's not just looking about the trading data, as David explained, it's about the context around those individual trades. And that often means we're looking at more than one source. It's maybe not just looking at one key piece of trade, but what were the emails going on around that, right? What were the chats? What kind of policies and procedures and approvals happened? What are we seeing for different timing of when dividends were actually provided? And it's about connecting all those different sources to help inform the broader picture. And also who is involved, right? How do we connect to the individual trader and what that person said in the chat, to his or her emails, to his or her trading? Again, to really focus in on what we want to do here, which is ask better questions. The data rarely tells us with absolute certainty something bright line, yes or no. But what it does is help us focus in on hotspots, key areas of interest. Who should we be talking to? What are the relevant time frames? What are the issues? Where do we sit in David's chart relative to the short seller, the lender, the buyer? Right? Where do you fit potentially into the overall scheme that we're looking to investigate? Where are we seeing those types of patterns? And that's really what we're looking to do here. Tessa, you wouldn't mind hopping along to the next slide. So what we have here is not necessarily a single tool, but a framework we often use to think about this. So on the left side, we think about kind of what our data sources are. I think that goes back to Annabel's kind of thinking about it in the product life cycle. I think that's a great way to conceptualize it, and thinking about all those pieces. Because as we think about it, some of those stuff are going to be spread across your organization. Your trading data may sit in one or more systems, depending on how your institution grew through acquisition. It may be stuff that's backed up and off-site, maybe on-site. That's why it's important to identify the stakeholders who have that information, being able to restore it, understand its limitations. Did it get corrupted? What time periods does it cover? Is it potentially inaccurate, incomplete for some reason or other? Right? That's something you want to uncover. And also thinking about emails. Where are those stored? Are those backed up? How do we bring those back? What kind of approvals? Is that a hard copy? Is there a system in place that tracks those approvals over time? So thinking about all those pieces, who are the stakeholders and where they actually sit from a data perspective is an important first step in any kind of investigation. And it's not just what's in your organization, but what data sources may be external to your organization. For example, if we want to look at trading that occurred around the timing of dividends, what data sources are available to us that we can use to help line up that dividend declaration dates with our trading information, for example. What do we learn from other litigations that we may want to bring into our analysis? So as we think about taking all that data, we then kind of migrate it into what is the actual analysis we're doing. And this can be where the bulk of the data analytics takes place. Up as much as 80% of any analysis is taking that data and being able to clean it and transform it and bring it into a usable, digestible fashion. We call that often enhancing the data. And what we want to do is think about how it connects to each other, right? Do we have employee IDs, employee names? How do we relate these different data sources together? How do we take our dividend declarations and the different stocks that issue and tie that back to our trading data? It's connecting all those pieces and thinking about what are the right tools we have, the right technologies we have that best fit each of those. So part of data analytics is bringing that tool and technology to bear. And that may take the form of something like a relativity or an Everlog. That's a document review tool that allows us to go through large amounts of unstructured data and do things like keyword searching. That is vital to culling down to where the kind of key pieces of information are. We can do things like sentiment analysis that tells us whether an email or a chat was positive or negative. Was it something that people were concerned about? Again, trying to focus in on the key pieces of information. We've got tools such as these programming languages such as R and Python and SQL, ways to manipulate very large amounts of data in a very consistent way. And then ultimately, we have things that are more visual, like Tableau or Power BI, that allow us to take all that data, all that structured and unstructured information, and present it in a way that shows those trends and anomalies in a very, in my view, clear and compelling way. Something that actually sees the lines, right? When we have spikes in our trading activity, and being able to really not just see that in a static way, but in a way that's dynamic, that we can change assumptions relative to what time frames we're looking at, what particular stocks, we can drill down. And that gives trading experts like David and compliance investigative experts like Annabel a way to really use their expertise and interface with a large amount of information in a way that's accessible to them. And that's really what we're doing, is taking our data, looking at performing analysis, and really just taking a moment on the risk scoring. How do we take all that information and think about what combination of factors leads to something that is potentially high risk and where they may want to focus their limited resources. And then taking that output and putting it in something that's visual, that the dashboard, so again, something that's dynamic, and ultimately managing that process in a way that, when at the end of the day, a regulator or there's a legal proceeding, we can go back and show those steps about here's our output, but equally importantly, how do we arrive at that final conclusion? So again, that's high level, but I think it's important to think about, again, data sources, what tools and technology you have, and then thinking about doing the whole step in a way that is clear, because the last thing you want is, the first time you're thinking about this is when the regulator does come and ask for that data. And I think, and Dave, you can touch on this, from the US perspective, it's no longer the case they want high level information. Regulators are asking for the underlying data and the data sources that the company should be having, they should have available. And they're not going to be happy if what they receive is unclear, inaccurate, incomplete, or takes a long time to produce, or is unresponsive. And that's why doing that investigation up front can really better prepare you for those potential regulatory inquiries and help you understand your risk and exposure as part of this. So I don't know, David or Annabel, anything else you want to add there?
Yeah, I was just going to echo, if I could, Josh, one example sort of prove the point. In before CumEx, there was probably a lot of people on this webinar were interested in LIBOR, and perhaps now more so than me, when I was representing a number of defendants who thankfully were all acquitted in the LIBOR trials. But part of that was because we used data analytics to understand the movements in the LIBOR rates in such a way that we tied that back to the chats, the Bloombergs, the messages, and all the rest of it, but also tied it back to what the data actually was showing us. Because it looked like, for example, you know, the LIBOR submissions had gone up on one day, but actually when you looked at the data in the truest sense, you could demonstrate that even though the chat said X or said Y, nothing was actually done, because you could then interpret the data in a different way to demonstrate that the allegation that these people have been involved in LIBOR manipulation actually wasn't true, that they were just effectively saying whatever they needed to say to their clients to make their clients feel a bit better, but they actually weren't doing anything. And so it was drilling down on the data whilst using the chats in a different way to the way in which the SFO used them, that I've certainly from my experience was very compelling before a jury in that scenario, because it allowed us to prove the point that actually the brokers in that case hadn't done anything wrong at all. And so using data analytics can actually be one of the most vital things in determining a positive outcome for your clients.
Yeah, I would agree with that, David. And I also think we were having quite an interesting discussion in the planning of this webinar around what the kind of red flags we might be looking for within the data, and comparing and contrasting those with sort of a completely different scenario of a rogue trader. So, you know, obviously that would just be sort of potentially one big position that's being hidden in various different ways, held by one individual or one desk, whereas this, I think CumEx, as you've just said, is much more similar or akin to LIBOR, where it appears to have been more systematic across the board. And what we'd probably see in terms of red flags in the data would be more, you know, spikes in trading pre and post dividend announcements and that kind of thing.
Absolutely, and also whether in the communications there are certain sort of, if I could call them sort of trading code words for a non-CumEx trade, but then for a CumEx trade it might be a different code word. And you'd also be interested in looking at the pricing of these various products, but you couldn't look at one product on its own, as in one of the trading legs. You might need to look at all of them. When we come to the questions, there's an interesting one about which I won't turn to just yet, but about how does B profit from this, because he's not making the withholding tax reclaim, but he's right in the center of it. So I'll answer that in a minute when we turn to questions.
Yeah, we can turn to questions. And for what it's worth, as you know, David, I asked you the exact same question in the planning session as that yesterday. So it's a great question.
Yes, it was. It was sent on email through Tessa, and I've picked up on it. So B, who's right at the centre of it, but isn't on the face of it submitting a withholding tax reclaim or getting any tax benefit, because it's the body, if you like, and the arms are on either side. A and C is on either side, and B is the body. It effectively controls the process, if you like, because it matches up all of the parties, and therefore its profit, if you like, from this trading or investment scheme, or however one defines it, comes from pricing, because there are obviously costs, significant costs associated with a CumEx trade. You've got to pay for the borrowing of the shares, and that wasn't cheap. You know, the owners of the shares knew the value of them around the dividend date, and they charged a premium for loaning out their shares. You've got the costs involved of using interdealer brokers for carrying out various legs and so on. So not only are you not making a withholding tax reclaim, you're actually carrying quite a lot of the burden of the actual costs of carrying out the trading. And so the way in which B can benefit is effectively pricing the products in such a way that it receives, if you like, upfront, ahead of time, a part of what ultimately would be the withholding tax reclaim submitted by C, or as I say, or could be multiples of C, but at least one of C. And so it's done through not an obvious, here's your kickback, if it was in a sort of old-fashioned criminal parlance. It's not a kickback. It's derived. Its profit is derived from pricing in the value of that second withholding tax reclaim into its products. And again, that would be an interesting data analytics point as well, because you'd be able to see that potentially, that price differential between a CumEx trade and a non-CumEx trade. Because in a non-CumEx trade, there might not be a 25% scot-free benefit to one of the parties. I use the term scot-free just because it seems an interesting point to understand for those of us international guests on this webinar, but we have the expression getting off with something scot-free. It actually comes from the Danish or the Norse scat-free, which was tax-free. So I hope that's an interesting point to note. I can see, Julia, there might be another question coming.
Yes, there is another question, and I parked it earlier on, so I hope that the individual from the audience is still with us. Otherwise, you may want to follow up with him individually. But the question is, what are the major implications of this dismissal by the English High Court of Denmark's claim against Sanjay Shah, and how will this affect future CumEx cases in the UK?
Well, the short answer is it's big. I think it's going to have an impact on how keen the regulators are to take on the whole big question of whether CumEx trading as a matter of English law or the application under English law of the national tax rules of another nation is something that it really wants to get involved with. I think what's been indicated by SCAT so far is it's going to appeal against that judgment because on the face of it, that's the end of their civil litigation. Unless they're in the UK, I should say. Obviously, they've got proceedings ongoing in the US and I believe elsewhere. But it's going to have a putting on the brakes on the one hand. On the other hand, if the appeal's unsuccessful, the FCA can then carry on with its investigation, because that was in an earlier interlocutory ruling. The FCA investigation was put on hold pending the outcome of the civil hearing. So it might work both ways. The truth of the matter is there is much more appetite for both making criminal investigations in the jurisdiction which received the loss, in other words, Germany, Denmark, Austria, wherever it may be, and the individuals and corporations are finding themselves involved in those investigations. And so there's a significant part that we can play in London to help manage that situation. But of course, you know, if you're an individual or a foreign entity, sorry, a UK financial institution embroiled in that, you will need to have local domestic counsel as well, because under German law, for example, only a German lawyer is allowed access to the prosecutor's files. And in any event, you'd want to have local counsel representing your interests. But when you're talking about an investigation, those matters are different. You might recall in I think it was in the Volkswagen scandal, that one of the internal investigation firms that was being used was the German subsidiary office of an American law firm. And German laws on privilege are completely different. And they were raided and had all their files seized, which probably didn't please their client one bit. Whereas again, under English law, that would have been a different situation. Going back to Annabel's point about how you set up your internal investigation and make sure that you're taking advantage of the privilege laws that you need to in the jurisdiction most favorable to your investigation.
So we're 5 minutes over time. Some of our participants had to drop off. There is another question. I don't know if the panel wants to take the question or if we want to wrap up.
I'll just quickly deal with that. There is some dividend arbitrage trading, but not CumEx trading that's ongoing and could be caught under the Criminal Finances Act. But it's not CumEx, so that would take a different form. But I'll be happy to receive an email and deal with that individually if there's a specific aspect that's being requested. But I'd just like to say my thanks to everyone for attending and to have such a great panel to work with. It's been a real pleasure.
Thank you, David.
Thank you. Well,
Thank you.
It sounds like we would have, you know, room for part 2 in this discussion with lots of questions and lots of things to talk about. So thank you very much, everyone.